I'm attorney Roger P. Foley, and today I'm going to talk to you about the Donald Hartung trial. There was a verdict last night, only several hours after the jury began deliberating. They came back with a verdict. Obviously, in criminal defense cases, when the verdict comes back so quick, it's almost always guilty. So every defense attorney, when they're dealing with a trial, wants the jury to take their time to go back and forth, waver and vacillate. I always talk to juries and say, look, if you go in the back and you pick your foreman and the foreman says, okay, either write it down or raise your hands, how many people think the defendant's guilty? And one person goes like this, and two-person, and everybody says guilty. Well, okay, there was no wavering and vacillating, right? However, if one person goes, yeah, I think they're likely guilty, but I don't know, there's a couple of issues that I had. Well, that's wavering and vacillating. So I think you need to explain that to a jury. Big mistake in the David Hartung trial. Although the defense counsel was outstanding, the closing wasn't outstanding. Why? Because it was same tone, same speech. There was no acting. There was no, hey, let me tell you about this exciting case that I got. You just heard the facts, and this is what I pointed out. I hope you got this. I hope I'm good enough to explain it. I hope that you saw it, because this man is innocent. This man is innocent, right? There was none of that. One thing he said, when he goes back, he goes, look, folks, if you guys go back and you go, hey, he's possibly guilty, or maybe he's guilty, or I don't know, it's close, well, then you got to come back with a not guilty. But what he forgot to say was look, if you go back there and you go, oh man, this guy is so likely guilty. I mean, it's just, my God, it's 95%, I'm sure. But there's just a one little scintilla of doubt, just a drop of doubt, a reasonable doubt. Not that the Martians came down and committed the murders or anything like that, but just a little bit of doubt, hey, you know what? Maybe that detective just jumped the gun a little bit too quick and started the evidence, or, oh my goodness, the crime scene tech. I mean, how good are they? I mean, these people are being fired and arrested for drug trafficking because they're stealing things from crime scenes. Or, hey, there was some DNA evidence of another person on the knife or on the checkbook. You know what? Maybe there was someone there. Apparently the police didn't follow that trail. That's reasonable doubt, folks. And if you got to yell, if you got to change your tone, sometimes you got to speak in a whisper so everyone focuses on what you're saying, because they don't want to hear anything. And sometimes you repeat things. Sometimes you repeat things. Sometimes you repeat things because you need to make sure that the jury is focusing on what you want them to focus on. It's important. So listen, folks, I thought it was a great trial. I think that defense did an outstanding job, but for the closing didn't match the state's closing. The state was methodical, and they had the boards, and they had their computer graphs, and they showed scenes, and they showed you exactly what they wanted you to focus on, and said, ladies and gentlemen, how many coincidences could we have? He's got a reason for everything. But he can't have a reason for everything because he's guilty. That man is guilty. And yeah, they said, okay, well, the snitch is a snitch. And yeah, there's some baggage that comes with him. But the state did an amazing job, such an amazing job in their closing. It was concise. It was to the point. They knew when to sit down. And she did use tone, and she did focus on things. And folks, I got to tell you, the defense counsel throughout the trial, they're cross. All right, hopefully you're back. It looked like the screen went dead for a second. I must have hit an area where my phone just wasn't connecting good. So anyway, I was saying the state attorney in her closing was concise. They told you what to focus on. They didn't focus on all the bad things for them. They didn't show all the loopholes. I think the defense concentrated on trying to, like, tick for tack, ping pong, boom, 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 boom. Everything that the state said in their closing, it's like the defense counsel was trying to make a point of it. You know what? Some of those things were things that you just leave. They're not that important. Focus on the closing. Give them the closing. Give them the fireworks. Give them the explosion. Give them the logic and tell them exactly why Donald Hartung is not guilty. Donald Hartung is not guilty, one, because the state can't even tell you when, for sure, when the time of death was. Two, right? You had police misconduct. You had a messy police investigation. It was sloppy. You heard our expert. He's an expert. Sloppy investigation. Donald Hartung didn't need the money. He had 40 grand in the bank. Okay, so what hurt? What hurt the prosecution? What hurt the defense? The money being deposited in the bank. That's my thought. They said that there was testimony that the brother RT always had hundreds, if not $1,000 in his wallet. He was always holding cash. And then a couple days after the murder, $100 gets put in, then $900 put in. Okay, so the logic from the defense counsel in closing was, look, people put money in the bank. I mean, people have money, they get money in different ways, and they put it in the bank. Why not have explained where that money came from? Why not have looked further into his bank records and asked questions about other times where Donald Hartung had put $100 or a few $100 or $1,000 or $2,000? Because, folks, you know, if you pull 3 years of records, you could say, you know what? It was a year ago, and he doesn't do it all the time, but, you know, once a year or so, you know, people get an income tax check or they get a bonus at work or somehow tied it together. It just left out there. So that testimony, it was a cumulative testimony. This was a circumstantial case. There was really no direct evidence like it wasn't his, DNA or fingerprints on the knife. I got to think of all the good things for the defense. It kills me, this case, because there were so many good things for the defense. Okay, he fought. And we're connecting, Okay, we're back. I don't know. I'm hitting drop spots on my way back to the office. So there are so many things to concentrate on. The one thing I didn't hear is like, hey, folks, I heard from the defense counsel, especially during closing, he went to the police. He voluntarily gave his DNA. He voluntarily was willing to give a polygraph. What about the marks? There's no marks. There's a struggle with a 280-pound guy. He doesn't have a bruise. My goodness, the guy's in his 60s. Everybody in their 60s. I don't know what it is, right? But if you bump into a coffee table, you got a bruise. If you stub the side of the bed, you don't think if you're dragging your mother's body that weighs 280 pounds, maybe you bump something. There's no bruises on this man. There's no scratches on this man. I mean, he just took down 3 people in his 60s. Like, there's no issues? Come on! Like, of course there's issue, folks. Think about it. I don't know the age of the jurors, but I mean, if you know what your case is in the beginning, and I didn't see the voir dire, I don't think anyone saw the voir dire, but you got to ask questions about things that you think could be relevant. Again, I'm not knocking the defense. I thought that they did an astounding job from direct through cross-examination. And then when they presented their witnesses, I thought their witnesses were stellar. But the closing, it just kind of reiterated the same thing 15 times. And if you don't get the attention of your jurors, if you don't change your tone, if you don't whisper, if you don't get excited, you lose the jury. You gotta be there. I truly believe that this case, my heart tells me, I could be wrong. I was wrong on the verdict, right? My heart tells me that the case was lost in closing. The neighbor was difficult. The money being deposited into the bank, the 100 and the 900, was difficult for the defense. But there were ways to get around that. Could have asked the neighbor other questions about the other neighbors. I mean, he's got a neighbor on one side and a neighbor on the other side, right? I mean, people go up and down the street. I would have been asking questions about that. They took his depot, so you know he had the time to ask the questions. So the guy had a hurt foot. Oh, he was like a video camera, the nosy neighbor. He pays attention to everything. The problem is he kind of defense validated that he knew everything, and you don't validate a witness. You say, look, he had a hurt foot. He was helping his wife. Everyone's helped their wife. Honey, it only take a second. Could you just help me? But it takes 2 hours to help your wife. You think that might have been something to say? I helped my wife. Hey, honey, can you just grab that garbage right there? Sure, honey. Oh, honey, while you go, I left some stuff. Hey, honey, there's some paper that the dog ripped up in the yard. Could you pick that up? Next thing you know, I'm raking and I'm picking up dog poop, and it turns into a 2-hour thing. And if it turned into a 2-hour thing, I couldn't have been staring at my neighbor for 6 hours of a day. There were some mistakes. Overall, I thought the defense did a great job, but the truth is the prosecutor did a better job. It's a guilty verdict. Are there appellate issues? I don't know, probably. Were there some things that came in? Why is the Wicca religion in? I don't know, maybe it's appellate, probably not. We got a result, folks. The jury has spoken. The man is guilty of a triple homicide, and they come back Monday for sentencing, and if they came back that quick, you think they're going to recommend the death penalty? Probably so. I don't think it's a mystery. I'm attorney Roger P. Foley. I truly, truly, truly enjoyed commenting on this case on Law and Crime. I appreciated the judge in this case. I appreciated the prosecution in this case. I appreciated the defense in this case. It was textbook law school stuff. Just really good lawyering overall. Again, closing lacked. You got to have a little emotion. It lacked in the closing, and I think that's where the case was lost, along with the neighbor and the money being put in. If you could have attacked that a little bit better in cross-examination, maybe you'd have a different result. Maybe you'd have a hung jury. I'm attorney Roger P. Foley. That is my analysis of the Donald Hartung trial. Thanks for listening.